Good morning, friends. Some of the audience, they asked me to make a video regarding the powers and functions of the executive magistrates. So normally you might have come across a tahsildar or somebody, whatever it is. Today we are going to learn the powers and functions of the executive magistrates. I am sure you are confident about the Crpc, that is Code of Civil Criminal Procedure 1973, which is a procedural law and which gives the powers to the investigating agency as well as the magistrates and judges how to conduct trial of a case. All these things you know very well. Now, according to section 6, there are different types of courts. Besides the High Court, there will be a Sessions Court followed by additional District and Sessions Court, then Sub-Court, then coming to the Magistrates Courts, Magistrates First Class, Second Class, and later the Executive Magistrate Court. Right, Class 4 says about the Executive Magistrate Courts. So that means, what is an executive magistrate? First of all, let us know who is a magistrate. A magistrate, this word has emanated from the Roman letter magistrus. Magistrus means the highest authority having both judicial and executive powers. So slowly this magistrate has come to the level of judge, and now the judges have been divided. So judicial authority, that means normally they will try the case, they will send the accused for remand, they will give the judgment, all these things their function. Whereas executive is nothing but administrative work. So the judges, they don't move out, they don't stir out, they will be in the chambers or in the court hall and delivering the judgments. Whereas the executive magistrates, these people, they have to move in the public. Whenever there is any law and order problem, they have to take immediate action. So the executive powers, as far as the constitution is concerned, the powers are divided into three organs. One is legislative, second is executive, and the third one is judiciary. But at times the executive will have a so-called judicial functions, and this is what is I am going to tell you. Right? So section 20 says and describes in detail about the executive magistracy. So I will come from the lower level. So there is an executive magistrate in a mandal level. He is called mandal executive magistrate. So normally the revenue officer like tahsildar will be appointed. Then above him the subdivisional magistrate. Please remember the word. Normally when you know that taluk executive magistrate or mandal executive magistrate, you normally you think that the RDO will be the subdivisional executive magistrate, but according to section 20 clause 3, the subdivisional officer or RDO, he will be designated as subdivisional magistrate. Of course, above all, for the district there will be a district magistrate. That is what section 20 clause 1 says. Of course, I have told you in the reverse order to make you understand the things easily. Right? So section 20 gives the powers of the so-called executive magistrates. So what are the powers? So there are different powers. We will divide it into 4 categories. Number 1, the most important power of the executive magistrate, maintenance of law and order. Maintenance of law and order. Yes, district magistrate is whole and sole responsible for the maintenance of law and order. So what is law and what is order? Law, as you know, law is a set of principles, rules or regulations decided by the government. And order, this is more important. Order means it is the absence of any violent crime or turbulence of violent cases, or also and absence of any writings. So if there are absent, then it is called as order. So law and order and public order, here you have to know. Law and order is different from public order. Law and order means if the writings are more in a village or in a particular area, then it is called breach of peace or affecting of law and order. But public order is different. Public order means, simple example I will give you. If a rowdy comes to the street and he attacks another person with a glass bottle or he attacks him with a knife, then what you will do? The entire area, immediately they will close down the shutters and go away due to panic. Out of panic, nobody will come and intimate even about the ghastly incident. This is the disturbance to the public order. Please remember, public order, law and order, there is a difference. Anyway, public order normally emanates from the protest virus. So many people come and they stage, they will kill somebody and go away. So at such times, to keep up the law and order, it is the duty of the executive magistrate. So therefore, section 46, first of all let us discuss about 44. Section 44 says, if anybody violates the law in the presence of the magistrate, definitely he can get him arrested or can personally arrest him. Section 46, the power of arrest, and they have to inform the police and also they have to inform the person about the so-called procedure and information of the arrest and use of minimum force. Yes, if the person tries to abscond, definitely they can use the minimum force according to section 50 Crpc also. More than that, 129 and 130, please remember, they are most important. So whenever the executive magistrate comes across an unlawful assembly, so 144 we have to know, but I will tell you later. So whenever the judge feels that an unlawful assembly is there and they have formed for dispersal of this unlawful assembly, yes, he can order them to disperse, and if they don't disperse, he can take the assistant of the police and disperse them. Here, police firing cases come. Yes. So normally, when the mob doesn't go, the police, of course, with the concurrence of the executive magistrate, when the situation is going out of control, he will order you to open fire. In such circumstances, the concurrence of the executive magistrate is 100% necessary, and he is the authority to decide whether the firing is justified or not. So he has to take a decision. Right, so here the force, normally why the police firing means it is a stage. First they will try to disperse them with the lathis, then they will use the so-called they will fire into the air, then only they will resort to the lathi charge under the guidance of the executive magistrate. That is the omnibus power given to an executive magistrate. Likewise, so when he is not there, some disturbance takes place and the police open fire, then there will be some inquiry, that is called magisterial inquiry. Whenever the police open fire in the absence of magistrates or in certain circumstances, they have to conduct the magisterial inquiry. Of course, the powers will be from the subdivisional magistrate. Right? So here you have to remember better section 94 and 97 also better you remember here. So please remember, whenever the executive magistrate gets information that certain things, certain stolen property, certain counterfeit coins, certain forged documents are kept in a place, then he can enter the place, conduct the search and remove the property. 97 says about the wrongfully confined persons. If the executive magistrate comes to know that certain persons are wrongfully confined, like the brick kiln factories, like the industrial lab, or some persons, kidnappers, then he can definitely enter the place and get them out without any such warrant. These are the enormous powers given to an executive magistrate. Normally, the executive magistrates don't know about these things. Normally, whenever the executive magistrate says, he will be noting down his name also. So they are there for preventive action. Please remember, definitely they are there for preventive action. Now the preventive sections start from 106 to 110 CRPC. Of course, 106 is not necessary for the executive magistrates because it's dealt by the judicial magistrate, and right from section 107 to 110, of course, they apply to him. 107, please remember, all these are preventive action. So normally at times I have seen the executive magistrates taken action after the incident, which is not correct, maybe by oversight, maybe out of ignorance, maybe on the influence of certain advocate. these things do occur. Anyway, please remember that when once the incident takes place, you are not supposed to take the so-called 107 action. Right. Let us know what is the preventive action or security for good behavior, security for keeping peace and good behavior. 107. So security for keeping peace. 2 points you have to remember. That is, if the executive magistrate receives information by police report or by sumoto or by any other source that there is likelihood of breach of peace, that means there will be failure of law and order and disturbance to the public tranquility. Tranquility means after a day's work in the night, you must feel tranquilized. You must go and sleep happily. If there is any disturbance, then it is called disturbance to the public tranquility. So if there are sufficient grounds, then definitely he can send a notice to the persons and he can ask them to execute bonds for keeping good behavior. The maximum period is 1 year, for 1 year with some reasonable amount as security. The amount is not clearly mentioned, but some reasonable amount. 108. This is taking bond from a persons who spread the sedition. Sedition means propagation against the democratically elected government or creating differences between two groups basing on the religion, caste, minority, linguistics, race, sex and language, all these things. Such people will be dealt with under section 108 CRPC. So normally remember section 124A, 153A, 153B, 295A of the Indian Penal Code sections. Such people, they will be dealt with under this so-called seditious law. 109. This is a quite common thing. Normally, you might have seen the police catch persons during the dead of night and produce them before you. So the section says, whenever any person is found taking precautions to conceal his presence, and if it is confirmed that he is likely to commit a cognizable offense, then even cognizable offense, then he can be taken a bond for keeping good behavior. Of course, for normally this is for 6 months, and of course normally the maximum period is 1 year. Normally police people will be bringing such persons. So they say that this person is taking shelter under near the railway station or the near bus stand. Even though they accosted them, those people did not give the identity. After thorough interrogation only they gave their identity. Then in such cases, if the fellow is likely to commit a cognizable offense, his presence is there to commit a cognizable offense, then they can be bound over under 109. 110. This is for habitual offenders or offenders who have taken crime as a profession, like rowdies or like goondas or theft, robberies, housebreakers, theft, forgeries, and persons committing offences under Essential Commodities Act and EC Act, that means adulterators we can call them. So receivers of stolen property, kidnappers, and breach of trust of EC Act, all these things I tell you. Such people, they have to be bound over, because their always tendency will be toward the committing the so-called offense, because they are regular offenders or habitual offenders or repeat offenders. So for them, you have to call them, and you can take, whenever you receive information that they are likely to commit the crime, definitely the executive magistrate can bind them over for good behavior for a period of 1 year. Please remember, these are all preventive sections, right? Okay, normally, so when once you give notice, the procedure will be from 112 to almost 123 CRPC. So 116 is an important section where if you feel that, of course, till the end of the inquiry by the executive magistrate, you cannot bind them over. But if you feel that there are likelihood of breach of peace, definitely you can take interim bonds under section 116 clause 3. This is add interim bonds they call. Yes, definitely they are important. Right, now your powers. Suppose if the man gives an undertaking that he will keep peace, but he does not keep peace, what you do? Then the executive magistrate can remand him to custody, can send him to jail till the period of the so-called good behavior is over, or till he furnishes sufficient sureties, right? Second point, 122. If the person is not able to produce any sureties, then he can be sent to jail till the period. Suppose if he is able to produce the sureties, or if he is able to keep good behavior, if the magistrate comes to know about the same, 123 gives you a power to discharge them or to send them out. Of course, we can't use the word discharge because there is no charge sheet. Please remember, whenever you file a case or this is called information before an executive magistrate, normally the police use the word charge sheet, that is information. So normally the judge in the judicial court, they take it on file as CC number, PRC number like that, SC number like that, but here it is MC, miscellaneous case number. And the judgment delivered by the executive magistrate is called as the order or the finding. Right? So, of course, it is almost on par with the judiciary, but the terminology is a little bit different. Now, these things are over. Now, coming to the law and order point once again. Section 133 CRPC. Let us learn about 133. 133 CRPC says about the that is nuisances. Removal of nuisances. If the executive magistrate finds any debris across the road, if he finds any animals, stray animals across the road, and if anybody dumps his all the material, house construction material, then definitely, if people in the area complain that this fellow is developing his insanitary methods, definitely under 133, the executive magistrate has got every power to give a notice and evict the premises or evict the area. So it is also most important. More than that, 144. 144 is most important. Daily you come across COVID-19. Now the first weapon used by the police is 144. So whenever the executive magistrate basing on a police complaint or receiving information through himself that there is likelihood of breach of peace with the assembly of persons, so he can prohibit the assembly of more than 5 persons. 144A, he can prohibit the assembly of more than 5 persons armed with weapons. Nobody should gather with weapons. So definitely he can definitely he can give the prohibited orders. If they violate the orders, they can be taken to task. But once again, Disaster Management Act. Anyway, if anybody violates the public authority order, then they can be taken to task under 188 of the Indian Penal Code. Friends, remember here, the person whose order has been violated, he has to give a report according to 195 CRPC, not the police. When you give the orders in 144, when they are violated, definitely police can arrest them, but you have to file the complaint under 195 CRPC under section 188 of the IPC. It may be a bit difficult for you to understand. Please remember, 188 IPC is the penal section for violation of 144. 144 is regarding persons. Suppose if the executive magistrate receives information that there is a likelihood of breach of peace regarding the land disputes, then also he can take action. He can ask one party to restrain, or he can ask both parties to restrain. He can conduct an inquiry, and if he is sure that one party is correct, then he can ask the party to enter the land, and the other party will be restrained not to enter the same. This is another powerful tool, because they will be dealing with the revenue matters. So 145 CRPC, right? So these are the important duties. Now coming to the other, yes, miscellaneous duties also there. So coming to 167 CRPC, that is remanding power. So normally the executive magistrates, lot of them, they are having the confusion whether the executive magistrate can remand a person to custody, whether he can give a conviction to him or not. Now I am going to tell you. Section 167 CRPC tells about the remand procedure. That means if the police arrest a person and if they cannot complete the investigation within 24 hours, so they have to produce him before the magistrate within 24 hours. Suppose on that particular day, no magistrate is present because all of them have gone to Amaravati High Court to attend a judicial conference, judicial officers conference, nobody is there. In such times, according to section 167(2)A, the executive magistrate is competent to remand him to custody. To remand in custody for a period of 7 days. Normally, the judicial magistrate gives remand for 15 days. Here, 7 days you can send him. And the penal powers, I tell you, 122 and 123. According to 122, when the person is not able to furnish the surety, you can send him to jail till the period of the so-called security for good behavior is completed, or till he furnishes the surety. Yes, these are the two penal powers the executive magistrates have got. Now coming to 174 and 176 Crpc. You might have heard the word inquest. Inquest means enqueste. That means quest for the death. That means the reason or the apparent reason for the cause of death. So according to 174 Crpc, whenever a person dies other than under natural circumstances, then an inquiry should be conducted under 174 Crpc. That is what is called inquest, and actually it is the power given to the executive magistrate, but normally since they are both busy with the revenue work and executive work, this work has been entrusted specially by the order of the government with the police. Normally the police people take up investigation and they will conduct inquest. But in certain cases, the executive magistrate has to come and hold the inquest, where in cases of dowry deaths, when a woman within 7 years of marriage, if she dies of dowry harassment, the executive magistrate has to go and conduct the inquest. In a case of rape or 176 also I want to tell you. 176 is normally, please remember, inquest exhumation. It's not, the provision is exhumation. 176, please remember, whenever a death in police custody occurs, whenever a death torture by police occurs, whenever a rape by police occurs, in such cases you have the executive magistrate has to go and conduct the so-called inquest. He has to go and conduct the so-called procedure, entire thing procedure, and the post-mortem also has to be videographed. He has to examine all the witnesses. This is all regarding 174 and 176 Crpc. And please be thorough with the inquest report. You have to write fill up all the columns right from 1 to 26, and normally the executive magistrates, they are under the impression that the police will write them and he will simply sign, but there are certain difficulties. In Chirala, one executive magistrate, he was suspended because he simply believed the police and signed on inquest report, which was not correct. I don't want to go into the detail. Anyway, better be careful. Then these are, and lastly I want to tell you regarding dying declaration. So section 32 of the Indian Evidence Act tells about the dying declaration. A person who is under the last breath is about to die, normally it is presumed that he will not speak lies, he will speak truth only, and this statement can be recorded normally by the judicial magistrate. If the judicial magistrate is not available, it can be recorded by the executive magistrate. For that matter, the doctor. For that matter, the police. For that matter, whoever is present when he is about to die, definitely his statement has to be recorded, because it will be an exception to the hearsay evidence. Of course, you may not. And lastly, I want to tell you, you might have heard about the Joint Collector Court. He is separately revenue courts. You are authorized, and they are right from the rank of RDO, and you can give your disposal. It can be subject to appeal up to the level of the district court, district magistrate, that is collector, and of course the subdivisional magistrate like joint collector, they are competent to impound or to act or to take action under the essential commodity tax or things like that. And lastly, to conclude, I want to tell you, the executive magistrate or revenue people for that matter, they are competent to give sanction orders for prosecuting a person under the Arms Act, under the Explosives Act, all these things. So friends, in brief, these are the powers and functions of the executive magistrates. So please remember, you have got umpteen number of powers. In CRPC, normally you may not have come across such a deep discussion on these points. Anyway, better you get enriched your knowledge with these things and provisions of law. Of course, I could not cite the case laws because of the positive time, already 20 minutes coming. Anyway, you can forward this message, this video to all your executive magistrate friends, so that they will also have they can also enrich their knowledge and they can be well versed with their powers, functions and duties also. So I wish you all the best. Thank you very much.